Did you know there's a new type of company that's raising millions of dollars? It's not an LLC, it's not a C-Corporation, and you may already know a few of them. Today we'll be exploring what a public benefit corporation is. We'll be diving into SEC filings to look at risk factors, the general corporate structure, and learning the difference between a public benefit corporation and a B Corp certification. So to give a little bit of a background, a corporation is a legal entity that's formed under state law. It can sue and be sued, it can enter into contracts, and issue shares. A lot of people choose to file in Delaware because you have access to a specialized court system that is really experienced in handling business disputes. Every corporation generally needs two documents. The first is a set of bylaws, and this is basically a set of rules on how to run the company. It's going to give information on how to vote, when meetings are supposed to be held, how many votes are necessary to make decisions, liability provisions and waiver and indemnification. The other document that you're going to have is a certificate of incorporation. In some states, this is called your articles of incorporation, but generally it's going to state the name of the company, the amount of stock that is being issued and the value of that. And then you'll also have the different rights associated with the stock of the company. Another key aspect of this is the purpose of the company. So here's an example from Meta or Facebook, and this one states, the purpose of the corporation is to engage in any lawful act or activity for which corporations may be organized under the general corporation law of the state of Delaware. Now this is where the key difference comes up for a public benefit corporation. A company can be sued if it's making decisions that are not aligned with the company's purpose. So a famous example comes from 1919 when Henry Ford wanted to use excess income to provide benefits for employees, and the Dodge brothers sued. And ultimately, the court stated that the general purpose of the corporation is to provide a benefit for shareholders. Another famous example comes from 1986 when Revlon wanted to accept an offer to buy the company for non-price reasons. They thought that the lower offer would ultimately benefit employees more versus another offer that was at a higher price. And the court ended up saying that the decisions had to be made in a way that maximized shareholder value. Another example comes from 2010, and the court basically found that making decisions to defend a corporate culture is inconsistent with maximizing shareholder value. So you might be wondering if you could just tailor the statement of purpose for a regular C corporation to consider other factors, and the answer is sort of. In a case involving a lawsuit against Meta and Mark Zuckerberg, the court noted that the purpose could be defined to include other factors, but it's not going to be implied. And in another case, we see that the Delaware Chancery Court said that they could narrowly tailor the purpose to achieve other goals, but you would have to specifically state those in the charter. You might be wondering if you could also be sued for not fulfilling your corporate charter's purpose if you have a public benefit corporation, and the answer is yes, but there's currently no case law on this point, so it is kind of a new field. But we can see that in public company filings, this is something that comes up again and again in the risk factors. So a public benefit corporation is a legal entity, and a B Corp is a certification. And so you can kind of think of it as something like fair trade. It's certifying the company for meeting certain standards. To get the B Corp certification, a company has to complete the B Impact Assessment, which measures impact on workers, customers, community, environment, and governance, and has to score at least 80 out of 200 points. They also must amend their governing documents to reflect a commitment to stakeholders beyond shareholders. The cost of getting a B Corp certification is going to depend on your revenue. So for a company that makes under $500,000, the price will be around $1,000. And if you're a company that makes more money, you're going to pay up to $25,000. So now that we've covered the difference between those two, let's go see how this plays out in filings with the Securities and Exchange Commission and learn about a few different public benefit corporations, what purpose they put in their charter, and what risks they're disclosing to investors. First up, we have Zevia. Zevia is a public benefit corporation that was founded in 2007. and their goal is to provide 0-calorie, 0-sugar drinks by using stevia. Their annual revenue is around $150 million, and if you look at Article 3 of their charter, it states that their purpose is to create and provide better-for-you beverages, food, or other products that support the health of our consumers and their communities, promote the well-being of our employees in a supportive and empowering environment, and forge an enduring profitable business. In 2021, they did an initial public offering that raised around $155 million. To give a little bit of background, an initial public offering is when a company sells shares to the public for the first time. They ring that stock exchange bell and are going to file a Form S-1 with the Securities and Exchange Commission. And this is a document that's going to go over the business, risks associated with the investment, and a bunch of other disclosure requirements. And so when you look at their risk factors, they go on to say, the dual purpose may conflict with profit maximization. The mission outcomes and certifications aren't guaranteed. There might be greater legal exposure for directors and derivative lawsuits if people believe that the directors failed to balance profit and purpose. In 2025, Zevia had a lawsuit regarding their beverages, and it stated that they had false no preservatives claims because they contain citric acid, which the FDA classified as a preservative. They also had false plant-based and natural claims based on ingredients, yet the products contain synthetically manufactured citric acid. And there was a claim of false product of the USA because this was made without qualification, given that they have foreign sourced ingredients like stevia and caffeine. So this is kind of interesting because we're operating in two different universes. One is for these packaging and labeling claims, but then this also ties into the public benefit corporation's purpose, because they state how their goal is to provide better-for-you beverages. And so if they're putting in preservatives, that might be seen as not fulfilling their purpose, especially if they're marketing as no preservatives and no colors and these other things. Next up, we have Warby Parker. Warby Parker is a public benefit corporation that provides eyewear. Their annual revenue is around $771 million. And if you look at Article 3 of their Certificate of Incorporation, you'll see that it says, the specific public benefits to be promoted by the corporation are to provide access to products and services that promote vision and eye health, and to work towards positively impacting the communities in which the corporation operates. In 2021, they did a direct listing. Now, direct listing differs a little bit from an initial public offering. It's still filed on Form S-1 with the Securities and Exchange Commission, but instead of raising money, it allows people who have shares to list them on the open market. So they put money into the company, they have these shares, the company's doing well, and now they can sell these shares on the open market. The company itself is not raising additional capital. There's also no underwriter or bank required to do the deal. And the risk factors that they disclosed were the risks of derivative litigation and the risk that decisions don't maximize shareholder value. Next up, we have Vita Coco. Vita Coco is a public benefit corporation that provides beverages. You might have seen their products in your local stores. They have the coconut water. Their annual revenue is $428 million. And if you look at Article 3 of their Certificate of Incorporation, you'll see that their purpose is to engage in any lawful act or activity for which a corporation may be organized under Delaware General Corporation Law. The corporation shall be a public benefit corporation as contemplated by Subchapter 15 of the DGCL. The specific public benefit purpose of the corporation is harnessing while protecting nature's resources for the betterment of the world and its inhabitants through creating ethical, sustainable, and better-for-you beverages and consumer goods. Products that not only uplift communities, but that do right by our planet. Furthermore, in order to advance the best interests of those materially affected by the corporation's conduct, it is intended that the business and operations of the corporation create a material positive impact on society and the environment taken as a whole. If the DGCL is amended to alter or further define the management and operation of a public benefit corporation, the corporation shall be managed and operated in accordance with the DGCL. In 2021, Vita Coco raised approximately $30 million with an initial public offering. And in their risk factors, they disclose the risks of not achieving their public benefit purpose, derivative litigation. They also state how the public benefit corporation status may hurt financial performance and takeover prospects. And they state that directors may resolve conflicts in favor of mission, not shareholders. So as you can see, this company is kind of hinting at the Revlon case, where if they are doing acquisition or selling the company, that they might do a decision that doesn't take the highest price. We also saw another lawsuit in May of 2025 against Vita Coco. The lawsuit was brought by the Center for Environmental Health, which is a nonprofit organization that takes on various environmental advocacy issues. And in this lawsuit, that they claim that Vita Coco was selling coconut water products in cans or cartons that leach bisphenol A, BPA, a chemical known to cause birth defects and reproductive harm, and that they failed to provide clear and reasonable warnings to California consumers. BPA has been listed as a female reproductive toxicant and a developmental toxicant under California law. We see a pretty clear example that would go against our charter if you're putting it in this packaging that's leaching all of these toxins that can harm your health. That could be an issue that goes against your purpose, so it may lead to some derivative litigation, and it will be interesting to see how this plays out. Next up, we have Lemonade Insurance. Lemonade is a digital insurance company founded in 2015. They offer insurance packages for pets, homes, and life insurance, and their annual revenue is around $526 million. If you look at Article 3 of their certificate of incorporation, you'll see that their public benefit purpose is to harness novel business models, technologies, and private nonprofit partnerships to deliver insurance products where charitable giving is a core feature for the benefit of communities and their common causes. The nature of the business or purposes to be conducted or promoted is to engage in any lawful act or activity for which corporations may be organized under the general corporation law. So you can see that they are hinting at giving to charitable causes, which is a little bit of a nod to the Henry Ford case of wanting to invest in things for employees. In 2020, Lemonade raised around $319 million with an initial public offering. In that offering, they listed risk factors that included no guarantee of public benefit success, the risk of the B Corp certification and charitable giving, the conflicts between shareholders and stakeholders may be resolved against shareholders, and a heightened litigation risk if the company is found to have not achieved their balance between profit and purpose. Next up, we have Laureate Education. Laureate Education is a public benefit corporation that provides educational services with around $1.5 billion in revenue. And if you look at Article 3 of their certificate of incorporation, you'll see that their public benefit purpose is to engage in any lawful act or activity for which a corporation may be organized. And the specific public benefit purpose of the corporation is to produce a positive effect or rejection of negative effects for society and persons by offering diverse education programs delivered online and on premises, operated in the communities that we serve, as the board of directors may from time to time determine to be appropriate within the corporation's overall education mission. In 2017, the company raised around $420 million with an initial public offering, and the risk factors that they disclosed included that the public benefit corporation status may not deliver expected benefits, and that mission-driven decisions may reduce financial returns. Next up, we have Greenlight Biosciences. Greenlight Biosciences is a public benefit corporation that works on RNA technology, so you can think of vaccines, and they have an annual revenue of around $10 million. And if you look at Article 3 of their certificate of incorporation, you'll see that their public benefit purpose is to engage in any act or activity to improve the public health and well-being of the people and the environment by, among other things, engineering, developing, and commercializing biological products that can reduce chemicals in the environment and promote health through the delivery of high-quality, affordable solutions that improve outcomes for people and the planet, and to engage in any other lawful act or activity for which corporations may be organized. In 2022, Greenlight Biosciences raised around $207 million in a SPAC deal. SPAC stands for Special Purpose Acquisition Company, and in this type of deal, you are basically having a shell company that takes investments from investors and then merges with the target company. In this case, it is going to require an underwriter or a bank. And for the risk factors that Greenlight Biosciences disclosed, they stated how there's no guarantee of achieving the public benefit purpose. The mission may undermine financial returns. Stakeholder conflicts may override shareholder interests. And the risks involved with the disclosure obligations and ESG certification risks, the heightened litigation risk if they believe directors fail to balance the fiduciary duties, and that their public benefit corporation status may deter mergers and acquisitions or depress buyout premiums. Next up, we have Coursera. This is a public benefit corporation founded by 2 Stanford professors that provides various online learning opportunities, and their annual revenue is around $694 million. If you look at Article 3 of their certificate of incorporation, you'll see that their public benefit purpose is to engage in any lawful act or activity for which corporations, including public benefit corporations, may be organized. The specific public benefit purpose of the corporation is to provide global access to flexible and affordable high-quality education that supports personal development, career advancement, and economic opportunity. In 2021, Coursera raised around $438 million through an initial public offering. And if you look at their risk factors, you can see that they outline that there's no guarantee of achieving their public benefit purpose, the B Corp certification risk, that mission-driven trade-offs may reduce financial performance, that fiduciary duty conflicts may not favor shareholders, that they may be less attractive as a takeover target, and that their derivative litigation risk could create liability if stockholders don't balance their mission duties, and they also state the risks of a mission-driven culture. Next up, we have Chobani. Chobani is a public benefit corporation founded by a Turkish immigrant who got a SBA loan to take over a craft yogurt facility, and you may have seen their products in your local stores. They offer Greek yogurt, and they have an annual revenue of around $1.4 billion. If you look at Article 3 of their certificate of incorporation, you'll see that their public benefit purpose is to forge an enduring business that has a positive impact on people on the planet by creating delicious, natural, nutritious products that are widely accessible to consumers, to provide a safe and supportive and inclusive working environment, and to support positive social and economic impact in the communities in which we serve, and working to be good stewards of natural resources and responsible citizens of the planet. In July of 2021, Chobani was contemplating doing an initial public offering, but ended up backing out. But we can still see that the risk factors that they disclosed included no guarantee of realizing a public benefit purpose, balancing duties may undermine shareholder value, and that the derivative lawsuit risk could result in lawsuits for directors failing to balance the public benefit interests. Next up, we have Allbirds. Allbirds is a public benefit corporation that was launched through a Kickstarter campaign, and they offer wool sneakers, and I personally love Allbirds. I had a few pairs of their shoes and had no idea that they were a public benefit corporation, so it was kind of cool to see that. If you look at Article 3 of their charter, you'll see that their public benefit purpose is to promote and engage in any lawful act or activity for which corporations, including public benefit corporations, may be organized under the general corporation law. The corporation shall be a public benefit corporation that is intended to operate in a responsible and sustainable manner and to produce a public benefit or benefits as is to be managed in a manner that balances the stockholders' pecuniary interests, the best interests of those materially affected by the corporation's conduct, and the public benefit or benefits identified in this certificate of incorporation. So you can see that this disclosure is a little bit more general than the other ones, and I think this could be a strategic move that could potentially avoid litigation over the public benefit purpose. In 2021, Allbirds raised around $230 million in an initial public offering, and if we look at their risk factors, they detail how their status as a public benefit corporation may not result in the benefits that we anticipate, that if their publicly reported certified B Corp score declines, they may be harmed, and that their directors have a fiduciary duty to consider not only stockholders' interests, but also the public benefit interests. They also state how they may be subject to increased litigation, considering their duty to balance stockholder and public benefit interests. So we heard a lot about the risk of litigation over not fulfilling the public benefit corporation's purpose, but how does this play out in practice? Well, we might just find out, as there have been a couple different lawsuits that could result in this issue being raised. In 2024, we saw a lawsuit against Allbirds. This was claiming that they were tracking user data and keystrokes for people that use their website, and it ended up getting settled fairly quickly. Now, because their charter was a little bit more vague, I think that they could be shielded from liability as opposed to the beverage companies who included specific things about promoting health and all of those sort of claims. But in their Form S-1 filing, they went on about how transparency was one of the key pillars of their company, and so if they're tracking data from their customers and allowing third parties to view all of that data, you could maybe say that that is not very transparent of them. And interesting enough, the disclosures that these companies made on Form S-1 can result in liability if they were made with knowledge that they were false. So for example, if they knew about the beverages leaking these toxins, or they knew that the data was being tracked on this website, there could be liability for the company as well as the lawyers that were involved in drafting these submissions. So it'll be interesting to see how this plays out in the future. But I think from this we can see how the Public Benefit Corporation gets a lot of benefits in the way it makes decisions and the way that it can structure plans or sales of the company. So thank you so much for staying till the end of this video. If you are interested in forming your own public benefit corporation or have any questions about intellectual property, corporate law matters, or anything to get your business on the road, I would be happy to help. So I put a link to my law firm website in the description of this video, and I hope you have a wonderful rest of the week.